Good evening, it's Alex Woods here. I'm a civil litigator specialising in financial mis-selling, currently bringing a number of payment protection insurance claims on behalf of consumers. Now, today I want to talk to you about the issue of costs, i.e. what is going to be the cost to you of a consumer of entering into a no-win, no-fee agreement, bringing a no-win, no-fee claim, potentially to the courts, litigating a bank for the mis-selling of payment protection insurance, in the light of the changes, the quite seismic changes to the law and to the no-win, no-fee regime that have come into force post 1st of April 2013. So I'm going to speak just for a brief while, I promise, to tell you about the key headline facts relating to the changes in the law as regards running no-win, no-fee cases. If you are interested in financial mis-selling, this does not concern the personal injury sector. And then if you are interested in the detail of the legislation, if you're a specialist or a lawyer, then I'm going to post a separate video after this one, so wait for that. It'll come through in a few days or so. It'll go into the relevant sections of the legislation, etc. Okay, so the headline fact is that if you now enter into a no-win, no-fee agreement with a lawyer against the bank in respect of a payment protection insurance claim, a non-personal injury claim, because the law is different for them, then you will have to lose some of your winnings to pay for an insurance premium that will protect you against having to pay your opponent's cost if you lose, and you may also have to pay some of your winnings, your damages, to the lawyer who's representing you to account for loss that he's suffering to his legal fees following the 1st of April change in the law. That's his success fee, his uplift. Furthermore, the third thing you're going to have to deal with if you are a client is potentially having to fork out, and this is a guesstimate, around about £500 odd to pay for an insurance premium up front to cash flow the insurance premium. So that's the danger. Now you're probably asking, well, what percentage of winnings am I going to lose if I instruct a lawyer? And this is obviously where you have reached a dead end or a stone wall with the bank through the normal processes of making a complaint, perhaps appealing to the Financial Ombudsman Service if necessary, and you think you need the service of the lawyer because it's complex or because you're not satisfied with the payout that the banks have awarded you. So for any of those reasons, and you think, well, I've got no choice but to get legal. So that is the exposure, and the amount of exposure is probably going to be within the region of 25, perhaps as much as 40% of your damages will need to go to pay for the lawyer and to pay for an insurance premium. Okay, now I'm going to go into the detail of the insurance premium itself. Just look at my watch, I've got a 5:24 train to catch, and I've got just 10 minutes for this video bulletin. So the first key thing is just go through the success fee, the issue of the success fee. Then I'm going to go through the insurance premium, and then I'm going to save for the end something which may actually be of greater benefit than what you previously enjoyed under the no-win, no-fee regime. And it has a funny acronym because its acronym is QOCS. That's Cox. If you had a sad sense of humour and think that that's sort of a sexual term, well, I don't know what the legislators were thinking. Anyway, Cox is an acronym for Qualified One-Way Cost Shifting, and it could be quite a powerful weapon in your hands because it may do away with in the need for insurance altogether. So hang in there for the end of the video because I'll talk to you about what is only just round the corner. It's not been enacted yet, but it's likely to be enacted. Okay, so just to explain, lawyers, when they enter into a no-win fee agreement, the idea is that they lose as many cases as they win, and therefore they're entitled to uplift their fees because obviously they only get paid if they win their case, not if they lose, by up to 100%. Now, the change in the law, now traditionally they've always been able to claim their costs from the other side, because the rule is that the losing party pays the winning party's costs. However, because of the 1st of April changes, they now can't recoup that percentage of their legal fees that relates to the uplift, which, as I say, can be anywhere from 0 to 100% of their standard hourly rate, from the other side if they win. So that's a problem. And in order to deal with that, because law firms are likely to not want to continue in the no-win, no-fee sector unless they are able to recoup this success fee, this uplift on their hourly rate. In order to deal with that, the poor old clients can have to pick up the tab and have to start to pay a percentage of their winnings to the lawyer. Now, in our sector, financial mis-selling and payment protection insurance in particular, clients will be well used to having to part with 25% of their winnings as far as a claims management company is concerned, for example. So it may not be that much of a leap for a consumer to accept a loss of 25% of their damages to go to cover the lawyer's success fee. That's the first area. The second area is the insurance premium to protect you if you lose. Now, if you win the case, the principle is that the loser pays your opponent's costs. But once again, if you win the case, like the success fee, the law now says post 1st of April, you're not entitled, you're not allowed to recover the cost of that insurance, the premium, which is payable after the case is completed. Note, not like payment protection insurance where you pay the insurance premium at the beginning, payable after the case is completed. You can't recover that from the bank's lawyers, from your opponents. Therefore, you will have to pay for it yourself. And of course, the way you're going to be paying for it is when you win, you get your winnings, and a part of that winnings will go to pay for the insurance. And that could be from anywhere from the region of £1,000 to £3,000, perhaps a little bit higher. So it could be a substantial amount of money. So it's probably wise not to commence a claim, a no-win, no-fee claim, unless there's a reasonably substantial amount of money in the pot if you would, as and when you win your case. So, and then, as I said, there's the final issue, which is lawyers will be cash flowing your case, i.e. paying for court fees here and there, and paying for a preliminary review of your claim, and they will perhaps also, I mean, in my case, I do ask for clients to pay a sum of money on account, between £250 and £500. You'll now also have to find some upfront money to cash flow the insurance, because the insurer in the current climate are going to be nervous about waiting for you to win before they get the insurance. They're going to want you to put down £500 up front. Going forward, personally speaking, I'm probably likely to continue to charge the client £500 up front, perhaps £750 max, and then I will pay for that insurance premium on my client's behalf. So finally, to conclude, that is like a provisional or interim arrangement, because the changes on the 1st of April were brought about really for the benefit of the personal injury sector, because of, you know, the compensation culture and the government's dislike of the compensation culture. And I mean, my dislike, and perhaps your dislike, of people who can break a finger or crack a fingernail at work from doing something stupid and daft, get released from work on full paid for 6 weeks, be watching a television commercial on daytime TV in the comfort of their sofa with a nice cup of tea and a bun, and there's a little nymphette telling them that they can pick up the phone and they can sue their employer and they're likely to win £5,000. So they think, well, fuck that job, I didn't like it very much anyway, I think I'll bring up this personal injury claims company or personal injury law firm, and the employer's insurance company invariably are going to pay out because they don't want the hassle. So in order to deal with that compensation culture, these are why the changes are coming into place. Now, the big change that's of real benefit to you if you're listening to this video and you're in the personal injury sector, but also hopefully the law is going to be broadened to cover our sector too within the next, I don't know, 6 months or year, perhaps, is a qualified one-way cost shifting, or COX for short, which means that you will never have to pay your opponent's costs if you lose, unless you fall into one of a number of qualifications, such as you have brought the claim in a sort of spurious or a dishonest way, or it's been demonstrated that you've abused the court process, your claim has been struck out for demonstrating no reasonable cause of action. So things like that, things that apply to the guy sitting in the sofa with his cup of tea, bringing a claim, to try it on. So I'm hopeful that will mean that people with claims of genuine merit will still continue to bring them and instruct lawyers in no-win, no-fee claims, and I'm quietly confident that will take place. There is one little thing that you finally need to know about. Just to conclude, there is also a qualification that says where your opponent makes an offer at an early stage of proceedings, and that then at trial you fail to beat that offer, you fail to get more than the offer they've made, then you will be liable for the other party's costs, but only up to the level of your damages. So you may be in danger of suffering a hollow victory. Okay, that's a quick whistle-stop tour of the headline points of the changes in the law of the 1st of April 2013, the Legal Aid and Sentencing and Punishment of Offenders Act, that's now in force. And please do, as I say, look at the follow-up video over the next few days, next couple of weeks, which I go into the legislation in some detail. Many thanks.